Adrian is an attorney who offers extensive experience in cybersecurity, privacy and security rules, data loss and prevention, and medical malpractice. He works closely with healthcare professionals to manage liability and lectures on a variety of risk management topics. Mr. Senyszyn routinely leads practices through the breach notification process and represents practices investigated by the Department of Health and Human Services and the Texas Medical Board. He has been a member of the Mahaffey Weber Law Firm since 2019. Adrian, we're really thankful that you're able to join us today and appreciate all the insights that you will be sharing with us. Before we dive in and I start off, we'll just let you know that Adrian does not have any affiliations with Team LT. Yes, and that this is not to be used as a resource only, but not a legal document. So before we get started, we have a polling question here for you guys. And the poll is, your practice has just discovered a cyber incident or ransom attack. What would you do? So you can choose a variety of responses here. Panic, notify your IT, notify cyber insurance and carrier, have your IT wiped. Give you guys a couple of minutes to choose through these choices. It looks like the majority of you would notify your cyber insurance carrier or notify your IT and MSP provider. So Adrian, would you begin by telling us some basic definitions that we should all be aware of as we look at this topic today?
Yes, thank you. As we begin our cybersecurity journey today, we need to be aware of a few different definitions. First, we're talking today about a cyber incident, and that's an event that could jeopardize the confidentiality, integrity, or availability of your digital information or your information systems. The focus of our presentation today is really on the digital and electronic component that you have in your offices, whether it's stored on your laptops, desktop computers, cell phones, jump drives, servers, or up in the cloud through your IT provider. All of us who are working in the healthcare field are aware of HIPAA. A HIPAA breach is an impermissible use or disclosure that compromises the security or privacy of protected health information. What is protected health information? Well, it's individually identifiable health information that's held or transmitted in any form or media, whether electronic, paper, or oral. That information includes healthcare records, diagnosis or decisions on one's mental health. It also includes future payment that relates to healthcare. And that information needs to be identified with the individual or reasonably be identified with the individual to constitute protected health information. So that's the information that we're trying to protect and safeguard from criminals, cyber criminals, or from other people. In Texas, under the Identity Theft Protection Act, Texas uses a slightly broader definition, and it's not called protected health information, it's sensitive information. And sensitive personal information would include an individual's first name or first initial and last name in connection with either their healthcare information, or you could also have the person's first initial or first name and last name in combination with their social security number, driver's license, or financial account, such as a credit card or a debit card, along with the PIN code. So Texas has a slightly broader concept of what is confidential information that we're seeking to protect. And in Texas, a breach of the security system means essentially the same as what we find in the HIPAA rule, which is an unauthorized acquisition that compromises the security, confidentiality, or integrity of that sensitive information.
So, Adrian, we know that ransom attacks are one of the most common causes of cyber incidents for healthcare providers. Recently, we're seeing a significant variant of ransomware known as Maze. How is this different, and how has it affected practices?
Well, in the past, it was more common for practices to experience a broad, indiscriminate form of cyber attacks from criminals using basic but effective ransomware variants. An example of this would be a Dharma attack. These were just emails or attacks that were sent out using a basic code. They were effective because they could lock up a practice's system and require an encryption key, but they were very just general. They were putting out a lot of phishing emails or trying to get into systems just broadly and indiscriminately. There was no real methodology. In 2018, the FBI noted in a bulletin they put out, and let me just get to the right slide here. The FBI put out a bulletin and they noted that the ransomware attacks were becoming more targeted, sophisticated, and costly, even as the overall frequency remained the same. So that meant cyber criminals were finding that these broad ransomware viruses, while effective in the past, weren't becoming as effective now as new technologies were being put in place to help prevent these kinds of attacks. So they began targeting criminals. In the case of Maze ransomware and some of the other recent variants, the MO of these criminals is to first gain access to the practice's system and exploit it. They'll go in, they will take as much data as they possibly can, then they'll go through and they will also try to destroy as many backups to the information as possible in exploiting the system. And they do this before they launch the ransomware virus to lock up the system. Why is this important? Well, if they take your information off the system and they destroy your backups to the information, then you have no way to restore your data and information, and you're at their mercy. Now, this is where the MO of the Maze actors gets a little bit different than what we've seen in the past. Once they get the protected health information off the system, they will demand that the practice pay the ransom, or else they will post that information online for the world to see. And they have a website that they'll post that information on, and they'll even announce to the world ahead of time that we have compromised the information of a certain practice, and we plan to release this information within X period of time if the practice doesn't pay our ransom. For me and my clients, I have had a client recently within the last 6 months affected by a Maze ransomware event. They had clean offsite backups and they were able to restore without paying the ransom. But the cyber criminals, true to what they had promised, posted thousands of pages of healthcare records online for anyone in the world to take, download, use, do whatever they want with. And unfortunately, the government and other law enforcement agencies who investigate practices also become aware of this, and this incident has triggered several different investigations. And I think just moving forward, If we look at the most common industries targeted by ransomware in the fourth quarter of 2019 as reported by Coveware, and Coveware is a reputable forensic and computer company, we see right at the top of the list at 18.7% healthcare. So we know that the healthcare industry is going to be one of the #1 targets for ransomware actors in 2019, and I would expect in 2020 and moving forward.
So, Adrian, can we talk about what is the cost of a cyber incident to a healthcare practice?
Yeah, when you break it down, you have one, initially there is a financial cost and a financial stress associated with it. And as this slide shows, there are numerous different costs associated with providing the notification of a breach. You have legal costs, and I would say between $5,000 and $50,000 end up is an accurate figure. It's probably more so for a larger breach in the realm of $25,000 to $75,000 in legal fees. Forensics is going to cost you easily $5,000, but what I'm increasingly finding is the forensics companies that are reputable and good, there are a few of them, and they do definitely charge a premium. I recently had it's ongoing, a case where we have a forensic company retained to do a forensic exam of one server and one desktop computer. Just to do the exam, the cost of that is $32,000. So if you have a large practice with multiple servers, multiple computers, you can see that the costs of these forensics add up very quickly. If you have to give breach notification as a result of an incident, then you're looking at several dollars per record for each affected patient. So this is the mail out portion of notifying the affected patients. So in the case of, say, a 50,000 person breach, you're going to have to mail out 50,000 letters via regular mail. So you have a postage cost, a paper cost, and a handling cost. Once you mail out, you're required to set up a toll-free call center and man it for 90 days. Now, practices could do this themselves, but oftentimes it's just more efficient and easier to have a call center handle the calls. A call center if you have a 50,000 person breach, is probably going to cost you $20,000 to $30,000. And then each person who would receive a credit monitoring code, and this would be a credit monitoring for 1 year, the cost of that is going to be anywhere from $3 for large breaches, because you get the advantage of economies of scale. And in the smaller breaches, you might be paying upward of $10 to $20 per credit monitoring code for the patient. And then the last issue we have really is the reputational harm associated with it, which is the public relations that practices may need to spend money on to rehab their images. If we look at the same slide and just move down, there are other potential issues with government fines and penalties, and you have associated costs of government investigations. You also have the time and lost revenue that the healthcare provider and their office needs to spend to deal with the investigation. That loss of manpower and time can add up very quickly, and it's a significant expense. We have, again, the reputational harm and loss of goodwill, and there's a personal toll that's taken on the practitioner when they're facing the prospect of an investigation through the government or a potential lawsuit. With regard to one of my one of my practices which suffered the Maze ransomware incident. Currently, we have spent, I would say, approximately $130,000, and that includes legal fees, notification costs, call center, and credit monitoring. That does not include IT forensics, because we elected not to do forensics because we were able to conclusively establish that the Maze ransomware people had stolen the data. So there was no reason to retain a forensics IT person. And then an additional cost was due to the large size of their data breach. A class action lawsuit was filed against the healthcare provider, and that case recently settled, and it settled for more than we actually spent on the legal and the credit monitoring, the call center, and the customer notification combined. So in that case, with approximately 50,000 people involved, we're looking at spending approximately $6.50 to $7 per record. And I think I see we've gone backward, but I'm going to catch us up to where we were on the slides. And the next slide is a very timely email that came out just yesterday from the Department of Health and Human Services, the Office of Civil Rights, which is the federal investigative arm that investigates HIPAA incidents. And this is noteworthy because they find a healthcare orthopedic clinic in Georgia $1.5 million due to a breach affecting, I think this one affected about 68,000. It might have been more patients. And I note that their quote at the bottom of their announcement is really key. It says, "Hacking is the #1 source of large healthcare data breaches. Healthcare providers that fail to follow HIPAA security rule or the HIPAA security rule make their patients' health a tempting target for hackers." I think this fine and penalty is a warning sign to healthcare providers nationwide that the OCR and the Department of Health and Human Services are going to take a stricter and a tougher stance if practices aren't spending the time, money, and resources to properly put their documents into place and to properly have their systems protected. And you can see what they're pointing at it and picking at just above this quote. The OCR investigation discovered long-standing, systematic non-compliance with HIPAA privacy and security rules, and these failures included failing to conduct a risk analysis, implement risk management and audit controls, maintain HIPAA policies and procedures, secure business associate agreements, and provide HIPAA training to their workforce members.
So Adrian, what would you say a practice should expect after they report a cyber incident, either to you directly as a cyber attorney, or if you are assigned their incident through their cyber insurance carrier?
Yeah, and the first thing you're going to get is sometimes there's a slight lag, and I would say very short lag when a practice reports the incident to their carrier and the file gets set up and in the hands of a cyber attorney. But once it gets in the hands of a cyber attorney, which should be fairly quickly, there's going to be a flood of activity. There's going to be a call to obtain and verify facts and information. The practice is going to be emailed a business associate agreement and a legal services agreement. If there is a forensics need, then the practice, with the assistance of the attorney, is going to be entering into additional documentation. Oftentimes this is a master services agreement, and another business associate agreement. And then there's going to be an investigation of the incident. And the investigation of the incident is not solely done by IT or the attorney. A large majority of the initial legwork and groundwork for the investigation is done by the practice and with the practice's help. So we're really relying on the practice and their workforce members to provide the necessary information for us to analyze the information. For example, I have an ongoing breach that we're investigating. There is a lot of back and forth communication between the forensics IT company that we've retained and the practice, as well as the practice's IT company, just to get the appropriate software uploaded onto the practice's system so they can analyze the systems and perform their forensic evaluation. After concurrent with the investigation, I, as a cyber attorney, would be asking the practice, please provide me with your existing policies and procedures, your risk assessments pursuant to the privacy and security rule, and the risk management plan. What are these items? These are statutory required documents that healthcare practices are supposed to have in place to be HIPAA compliant. Oftentimes, the problem that we find is that practices just don't have all of those documents in place before the incident. And in that last press notification from the OCR, that was one of the items that they were picking on practices, or the Athens practice, about, was not having policies and procedures in place and a proper risk assessment in place. Very quickly, as we identify vulnerabilities in the practice's systems, we're going to identify corrective action that the practice should take. Concurrently, we're going to be working on ways to mitigate the harm to the patients who are potentially affected. So this process will be done in conjunction with the IT forensics company, who would help provide some information. We also may need to retain an outside HIPAA vendor to come in and perform HIPAA training to assist the practice put together a set of HIPAA compliant policies and procedures that are specifically tailored to the practice to help perform the risk assessment under the privacy and security rule and to get the risk management plan in place. So all of a sudden, in the first 30 days of this incident, you may have an IT forensics company, a cyber attorney, and an outside HIPAA trainer or vendor coming into your practice, and at all the same time, your practice and staff are going to be required to be updating your documentation internally and undergoing training. Once the incident is assessed, then we will make recommendations. If breach notification is necessary, we will be relying on the practice to provide the name, address, and last known contact information of every person who is potentially affected. And then once we send breach notification, if the breach involves more than 500 people, it may be necessary for us to send out press releases to set up a call center. And it also could lead to government investigations and lawsuit defense down the line. That is usually not triggered for about 6 months. I would say 3 to 6 months after a notification.
Should have started with this question.
Thank you very much. Well, I think the starting point with preparing for, preparing yourself for a cyber incident is understanding where cyber incidents are coming in and how the threat actors are coming in. We had referenced earlier the remote desktop protocol, or maybe I had not mentioned it earlier. Cyber criminals are often coming into the systems through the remote desktop protocol ports. And what is this? This is your remote door that gives you access into your systems. So if you have employees that are working remotely, they are accessing the RDP port to get into the system. And what cyber criminals do is they just set up, once they find that remote desktop port, they can set up a system to just run thousands of passwords an hour until that RDP port is compromised, and then they get in. So the largest threat that the healthcare practice is facing is a IT computer threat to your systems. And that relates back to your IT vendor and also you understanding what the threats are as a practice manager or owner. The other areas of potential compromise are email phishing and software vulnerabilities. Obviously, software vulnerabilities is an IT function, but it could be a practice issue if the practice decides not to invest in current software or the upgrades aren't being implemented properly. Email phishing does relate to the practice's staff, but it also has an IT component because oftentimes some of the phishing emails can be filtered if there is a proper filter on your email systems if you have a practice email system that your IT vendor is helping you with. So I think the takeaway from this, from Coveware, is IT is still your number one problem area that you really need to be focusing your time and resources on. So what do we do to prepare for a cyber incident with this in mind? Well, we need to budget time, money, and resources for prevention and training, right? We certainly need to budget the money for proper IT and proper technology to be implemented. We also need to budget the time for ourselves to be educated and our employees to be educated on the preventative measures that are put in place. Practices need to understand and implement specifically tailored policies and procedures. And this is a requirement under the HIPAA rules. And any state attorney general or any government who investigates a incident is going to be asking for your policies and procedures related to your IT system when they investigate. So it's worth the time and it's a requirement to have clear policies and procedures in place. We highly recommend that there's a competent IT vendor hired to manage the practice's systems. I know finding a competent IT vendor can be a little bit difficult and challenging. If they don't know what a business associate agreement is or have never heard of HIPAA or are not very familiar with it, that's probably not an IT vendor that you want to use. You want to use a vendor who's very familiar with HIPAA, and you want to quiz them on it. You want to be sure that they know what they're doing and that they understand the threats to your practice from cyber criminals. You want to have a risk assessment of the practice's system and IT network conducted. And even if the practice has an IT vendor that they know and trust and have used for years or feel that they do a great job, I always think it's a great idea for a practice to have their network independently checked at least once a year, maybe once every 2 years at most, by an independent IT vendor, someone who specializes in checking systems for vulnerabilities. There are these vendors out there that can do this, and they provide you with a written report that your IT vendor can then implement. So it's as much about making sure your current IT vendor understands and knows the threats that are there also, as it is just checking your system and making sure you're safe and it's really a double check on your system. Then you want to implement the changes in a risk management plan that you've set forth. So maybe you're considering your system should be segmented. You should always consider encryption Dual factor authentication also is another one that's not on the list. You want to consider your offsite backups, your remote desktop protocol, and importantly, you want to consider how you monitor your systems and audit them. So you're checking your systems to determine if there's any criminals or people on your systems who shouldn't be there. And importantly, you want to document everything in writing and keep it. So if you do end up having a breach and get investigated, you can show the investigators that you were properly auditing and checking your systems regularly. Now, one of the problems practices routinely have is this implementation component, and this is sometimes the most challenging feature. They have an IT person come in or a consultant and say, you need to do this, and for one reason or another, the changes aren't implemented. It might be a financial reason, it just may be a time reason. That is one of the areas that will get a practice into hot water with a government investigator if you suffer a breach. Did you have an IT company tell you or some vendor tell you that you have a vulnerability and you failed to correct it? That's going to be a problem. You should also be regularly training your employees specific to cyber incidents, specific to phishing and ransomware. You should not allow employees to use practice computers for their own personal use, and you should document all the training. You should also check your insurance coverage and cyber coverage, make sure it's adequate for your practice. I would recommend a minimum of $100,000 in insurance. That will get you close to covering a lot of the initial breaches for anything under $30,000. I mean 30,000 patients. In the case of a large breach, anything over 30,000 patients, you're probably going to exhaust that coverage, especially if there's forensics involved. So you really need to take a look at your practice, understand how your systems are set up, and understand your risks when you're evaluating the coverage limits that you're comfortable with. And then I always think it's a great idea for a practice to create an emergency contact list. You would have your insurance policy information with telephone numbers and contact information. You would have your IT company and their contact information. If you have a cyber attorney, you would put that person's contact information on, and you would have that available and known to several employees in your practice, because you never know when your practice manager or your HIPAA privacy officer is not in the practice one day and you suffer an incident that requires immediate notification to your insurance company, and you want to have other people knowledgeable about making that claim. And then you want to avoid common mistakes when an incident occurs. And this slide runs through some of the common mistakes, but one of the most common mistakes that is made, which was on our initial poll, 16% of the attendees had indicated that they would wipe their IT systems. That is one of the most common, and it's probably one of the worst mistakes you can make, because by wiping your IT system before a forensics company is able to get on the system and capture the data information, you have now erased the ability for the forensics company to determine who was on your system and, most importantly, if any information was taken. Just because you've suffered a ransomware incident doesn't necessarily mean it's a reportable incident. You still have the ability to make a determination whether there was a low probability of harm to the affected data. So if you have a ransomware virus that locks up your system and a forensic company is familiar with the virus and they know that it doesn't exfiltrate or take data off of your system, and we can forensically prove through our review of the logs that no criminal actors were on the system as a result of the incident, and it was just essentially a ransomware virus that locked up the system, there's a good chance we may be able to conclude a low probability of harm to the data, especially if you have clean backups, that would result in no notification. But if you wipe your systems, the ability to do that, I won't say is completely erased, no pun intended, but it makes it significantly more difficult to help prove a low probability of harm to the data.
So we're running a little short on time, but we want to get these last two questions in. Besides the Federal Health and Human Services Office for Civil Rights investigations, as well as the Texas Attorney General, are there other regulatory bodies that can be involved in breach investigations?
Yes, and here's a letter that has come from the Office of Attorney General in Indiana. They conducted a breach investigation related to a Texas healthcare provider that experienced a breach. So when you have a breach, you've got to think in global terms. And if you have patients who are residents of other states, then you have to also comply with the reporting requirements of other states. And those state attorney general's offices may be investigating you or your practice as well. So you could have the Department of Health and Human Services through HIPAA investigating you, the Texas Attorney General's office investigating your practice, and then multiple states investigating your practice. If you have to notify outside of the United States, which is a possibility, Canada and Puerto Rico, you might have a patient who is a resident of those countries. You may be facing a investigation from a foreign government. Also, you need to keep in mind that you could have a license complaint in Texas, which could result in a board case and a possible fine or sanction. And if you do have a fine and sanction in Texas and you're licensed in other states, you're going to have to report that to the boards of those other states, and they may investigate you. So there's a number of different agencies that you need to be aware of that could investigate the HIPAA incident.
So we hear from time to time that medical practices text with their physicians using standard texting technologies on cell phones. Obviously, that's not necessarily an encrypted texting application. So what's the danger of this?
Yeah, the real danger is if you don't have authorization from the patient, then you're texting information that is unencrypted and it's violating HIPAA. So although texting is just one of the easiest and most effective ways to communicate internally with your practice or with other healthcare providers when you're providing treatment, if you're not using an encrypted app that's HIPAA compliant, you are violating HIPAA, and you're potentially subject to the notification requirements for a breach. There's some other issues with that you got to keep in mind also, is the information is oftentimes on your cell phone. So if you lose your cell phone, then you have the potential that you have healthcare information on a device that is unencrypted, and now you have another breach that could be associated with the loss of the phone. And the last issue I see is really, it's a precedent that you set with precedent of non-compliance that other people in your practice might look at and see, well, the doctor's texting and there's a non-compliant, this isn't in compliant with HIPAA. Do we really need to be that strict with, faxing this letter or ensuring that this email is encrypted when we send it out? So there's several issues. The most important is just to understand that that's a violation unless you have the patient's authorization to communicate in that way.
We're getting near the end of our time, but we do have one additional polling question. Do you feel your practice is prepared to respond to a cyber attack or an OCR investigation? The The selections are yes, no, or unsure. It looks like unsure is kind of leading the way by about a 2-to-1 margin. So why don't you wrap it up for us, Adrian, and then we'll take a few questions.
Sure. Yeah, so if you suffer a ransomware incident, there are a few things you can do. Isolate the affected devices. So you want to immediately contact your IT vendor. Isolate. You may or may not want to power off the device. Oftentimes, if you can effectively isolate the device, you want to leave it running. You're going to want to notify, again, your IT provider, and they're the ones who are going to help you isolate that device. You want to immediately secure your backup data and information. That data should be secured in an offsite location, whether you use the cloud or a different practice location from where you're saving information or where you're treating patients. And then you want to immediately notify your cyber insurance carrier and get an attorney appointed. And then you're going to contact law enforcement and notify them about the incident. On this last one, really the order should be contact your cyber liability carrier, see if you have insurance, get your attorney appointed to advise your practice, and then the attorney will work with you in contacting the law enforcement agency and providing the appropriate notification to the FBI or IC3 agency.
Thanks, Adrian. That's been very informative. Couple of housekeeping things as we wind up today. Remember that you can click on the file name if you want a copy of the presentation. When it turns with a dark blue background, you click Download Files, and those will be downloaded. You can still type in questions. We'll take as many of those as possible. If you are wanting CME, there is a box for you to include your name and your email address. And since this program is approved for CME, your feedback is very important to us. If you would click the blue click here on the slide in the middle, that will open the CME evaluation in your browser. When the webinar is over, it will be there for you to complete. Adrian, we have a few questions. Let's start with, is the name, date of birth, and insurance information through email considered to be HIPAA non-compliance?
Right, so if we've got the patient name and we've got now, in terms of Texas, now we have a name and a date of birth and insurance information. There is an insurance record and related to treatment. So the insurance information typically will have some sort of explanation of the bill or an explanation of payment related to treatment. So one of the elements of HIPAA is that it relates to the past, present, or future payment of healthcare. So this is obviously a bill that is being emailed to the patient. If they haven't signed an authorization to receive healthcare information or HIPAA information via email, then yes, that would constitute protected health information. A cyber attorney would ask for the email and the information being sent just to see and confirm that. But by that basic description, I would say yes, it does constitute protected health information.
Great. Are we protected if we have a cloud-based EMR? I'm guessing protected from ransomware and other cyber security issues.
Remember, cloud-based EMR systems are not foolproof, because no system is foolproof to a hack or ransomware. If we have seen government agencies being hacked, so you have a level of protection that you should feel confident in, but you're not 100% protected. So what does that mean? You need to look at your business associate agreement with your cloud-based provider and understand what are the obligations between me and my cloud-based provider in the event a incident occurs. What are they supposed to do? You might also consider asking them, what kind of insurance do you have? What kind of coverage do you have? Who's responsible if you all are affected by a breach? This should all be laid out in your service agreement and also in the business associate agreement, but you can ask your cloud-based provider that information. Now, that being said, most EMR systems based in the cloud through a reputable vendor are going to be fairly well secure.
The next question is, recent articles have indicated a trend of companies embracing paying a ransom and filing their cyber insurance claim over using other remediation tactics. For example, even if they have clean backups.
And I think what that question's asking is, are companies avoiding their obligations by paying the ransom, and not instituting remediation measures? I need to maybe see that question a little bit better, but let me see. What you need to realize is, even if you have an incident and you pay the ransom and you get the information back, you have a reportable incident unless you can demonstrate a low probability of harm. So if you're able to get the system freed up and an attorney with forensics or with the help of the practice makes a low probability of harm determination, then you might not have to report that incident. However, whether you report it or not, the practice still has an obligation to have their training in place, have their policies and procedures in place, the risk assessment, the risk management plan, and to change those items in response to the incident. If that incident results in a government investigation, the government is going to require the practice to make those changes and institute those changes. And they're going to require the remediation. So, if practices are paying ransom but not conducting remediation, I think eventually it's going to come back to haunt them.
Great. Who are the cyber criminals, and is the FBI able to find, and I would say prosecute, these criminals?
The FBI is actively involved in investigations. In particular, that Maze ransomware incident, we were coordinating with FBI. Oftentimes, cyber criminals are extraterritorial, located outside of the United States. They range from foreign governments. There are small groups that are cyber criminals that arrange for the hackings. They could be small groups, they could be large groups, they could be state sponsored, they could be non-state sponsors. They also could be individuals or small syndicates. A majority of the ransomware incidents, or cyber actors that are launching these attacks, are usually from Russia, Eastern Europe, or from North Korea or some of the Asian countries. We do sometimes see cyber criminals down in Brazil and in India. With so many people in the world, there's just an opportunity for some intelligent people to get together and use the resources that are out there. So to answer the question, cyber criminals come in all shapes and sizes, but I think the most sophisticated are going to be usually either a criminal syndicate or a state-sponsored group that are using this as a way to make money.
Great. The next question is, if I am a referral physician to an entity that has had a breach, either a hospital or a large group like the Georgia Orthopedic Group, and have several patients that have their PHI in that breached system, what action should I take?
Well, if you're a referring physician, then you are not a treating physician per se. What I would do is I would look at my business associate agreement to determine if there's any obligation that I have to notify my patient about the breach. I would also speak to that practice. Now, if you've referred that patient over to that practice and they are completely independent from your group and there is no business associate agreement or other contractual arrangement between your practice and that practice, then it's really the obligation of that other practice to provide the notification, because it's notification to their own patient. So again, it's not your system as the referring physician who has had their systems compromised. It's the healthcare provider who has accepted that patient as their own and has had their systems affected. But again, just to reiterate, check and see if you have any contracts or agreements with them that would necessitate you notifying the patient, or you might have a relationship with that other healthcare provider that you just weren't aware of, and that relationship arose through a business associate agreement.
During the presentation, you had mentioned that cyber criminals can often find some port for remote desktop protocols and then run passwords until the system is compromised. Can this happen even without any employee opening a suspicious link or emailed file?
Yes, it can. And as a matter of fact, my law firm suffered these are called brute force attacks. And once they identify a port, and there are common ports known to cyber criminals they have a numeric digit known to them. So these are common ports that cyber criminals look for on systems that they can attempt to exploit. My law firm just last week suffered a brute force attack where cyber criminals were attempting to break through our remote desktop protocol systems, and we had to shut down the RDP ports that were being attacked and reconfigure and relaunch different ports that were unknown to the cyber criminals. It doesn't require a phishing email. It just requires an actor identifying the practice and their remote desktop systems that are exposed to the World Wide Web. So you have to think of your remote desktop protocols as being doorways into your system. Well, if those doorways aren't hidden, then cyber criminals who are looking at think of a building, they may see a door into your systems, into the building, and then they go up to that door and then they launch a system and just try to gain access to it, all without you or your employees being involved.
I think our last question is, if billing information is shared in an encrypted email or an encrypted spreadsheet, is it compliant?
Yes, generally yes, and I'll say generally yes, because there are protocols that are put out by the Department of Health and Human Services, and those are encryption protocols. So if your practice meets those encryption protocols, then it's generally going to be compliant. I would say a majority of all spreadsheet documentation and systems these days would meet the minimum HIPAA compliant protocol for encryption. But if there's ever a question, you would have to refer back to those protocols and have your IT vendor verify it.
Great. Thank you so much for joining us today, Adrian. If you enjoyed hearing, or maybe you didn't enjoy hearing Adrian's information, because it's kind of scary to hear about some of the things that happen in the world of cybersecurity from cyber criminals. Adrian is going to be our featured speaker at TMLT's fall seminar, which is Hot Topics in Medical Records, Privacy and Regulation, Reducing Your Risk. And those will be virtual in October, so watch for registration information coming to your inbox soon. Thanks, everyone, and we hope to see you for our next webinar.
Thank you very much.